I call the Honourable Member Carol Beaumont.
Thank you, Mr Chair. Mr Chair, it's a pleasure indeed to rise to speak on the Courts and Criminal Matters Bill, a bill that was dealt with by the Law and Order Select Committee prior to my membership of that committee, but one that I know has got general support. Certainly Labor supports this bill, and as my colleague Jacinda Ardern has mentioned, in fact this was commenced under Labor, and credit goes to Rick Barker, I think, and I'm pleased to see that it's actually acknowledged in the commentary on this bill that this was in fact commenced under the previous government. I think that's a good thing to note. Part one, of course, we're speaking on right now, and that's the amendments to the District Courts Act 1947. This is an omnibus bill and it covers a number of different acts, and this part solely addresses matters in the District Courts Act. So the matters that are in that particular section relate to attachment orders, and they are orders that allow for deductions to be made from wages and benefits to pay debt. Now, of course, the issue of debt is one that is a significant problem in the current climate, and it's not just about a whole lot of individuals who keep racking up fines and don't pay them. There are some people like that, I'm sure, but there are also, I think, many people who are struggling very seriously to make ends meet, who are incurring debt, and of course monetary fines as a punishment can in fact be very difficult for some people to actually meet. And so one of the particular things about this bill is to try and look at alternative ways that people can make amends or meet the requirements of any punishment by doing other things other than paying fines. But this is about attachment orders, which is about paying those fines, and the bill aims to streamline in this regard, as it does in others, this enforcement process by enabling judgment creditors to file a financial statement or ask the court to assess the debtor's financial means in the debtor's absence. Now, that is about avoiding delays and costs and inconvenience of bringing all of the parties together to do that. And so one of the things I was interested in, and I thought others who were on the Select Committee at the time this bill was considered might be able to help me with, I then note that there is an SOP around the attachments orders, SOP 202, which proposes the carrying over of the existing law that it is an offence for an employer to dismiss an employee or alter the position of an employee to the employee's prejudice because, amongst other things, an attachment order in respect of the employee has been served on the employer. Well, that sounds sensible to me. If the person's complying and doing what they're required to do, they shouldn't face the possible loss of their job, especially in times of very, very high unemployment as we're facing now. But as I understand it, the new provision removes the existing onus on the employer to prove that the employer's action were not taken as a result of the employee's debt or the attachment order. So in other words, it's weakening that protection, and I just wondered why that was, and I thought perhaps members of the Select Committee could perhaps elucidate the House on that matter about why that change there of removing the existing onus on the employer to prove that their actions in dismissing somebody, were not taken as a result of the employee's debt or the attachment order. The new provision consequentially removes the time limit for the protection provided to employees, which is currently 6 months. And again, I asked the question of those that were on the Select Committee what the reasoning was behind removing that time limit for protection. So that's a couple of questions about the attachment order, which I would be very interested to know the answer to, and perhaps the Minister and the Chair might be able to also help us out on that matter. Now, this part also talks about imprisonment for the non-payment of fines, and there also, as I understand it, provides for the period of imprisonment imposed under in respect of a non-payment of any fine, or where the sale of any property under the process does not produce sufficient proceeds to pay the fine, is such period, so the period of imprisonment is of such period as, in the opinion of the court or district court judge, fixing the period will satisfy the justice of the case, but it cannot exceed, in the case of an offence that was punishable, Mr Chair, punishable
I
by
call the honourable member Carol Beaumont.
So the period of imprisonment cannot exceed, in the case of an offence that was punishable by imprisonment, the maximum term of imprisonment to which the defendant was liable on the conviction, or a period of 1 year, whichever is the lesser. And in any other case, a period of 3 months. So it actually goes on to talk about that. Now, another area that is in this part of the bill, which I thought was interesting, and this is around, this has got a supplementary order paper 202 again, proposes to amend the provision of the bill as introduced, allowing a judgment creditor to apply to the district court for the judgment debtor to be sentenced to community work as a sanction for non-compliance with payment orders made by the court. Now, I'm assuming this is in the situation where somebody is really unable to pay the debt, and that it's providing an alternative way of the person actually meeting their debt to society, if you like, and so that we don't have a whole lot of people with substantial levels of debt that they're never going to be able to pay off, and fines actually hanging around. So it would provide an alternative, which is community work or other penalty, in fact, is what's referred to here. Now, there's also the provision in Part 1 for property and goods to be sold by the bailiff, and again SOP number 202 proposes that it be made clear that the purchaser of goods sold by a bailiff charged with the enforcement of a warrant to seize property acquires good title to those goods free of all ownership interests and other proprietary interests held in them before the sale. So this particular part of SOP 202 actually amends in Part 1 clauses 28 and 29, and also amending respectively sections 90 and 91 of the Act. So I just, in closing, really would be very interested indeed to hear a little more about this issue of employees subject to an attachment order, and why there has been a change to the existing law so that the onus of proof has changed, and why the time limit for protection has been changed. Thank you.
I call the honourable member